The argument for reparations, monetary compensation for slavery, reparations for slavery, fails under the law. Now, this is dealing with an ancient law of Germanic people, and that includes the Anglo-Saxons or the English, who are the ancestors of most white, probably most white Americans. Uh, this is dealing with something known as wergild, and now let it explain what that is. Anyway, it says here, this is dealing with slavery, Anglo-Saxon England. Slaves had no wergild or mangold worth, but as property, slaves had value. If a slave was killed, the slave's valuation, generally a pound, the price of 8 oxen, was to be paid to the aggrieved owner. If the owner himself killed his slave, he incurred ecclesiastical penalties, that is, dealing with the church, but rarely legal ones. Alfred's law code underscores the notion of property rights. Alfred was one of the older kings of England. If anyone rapes the slave of a commoner, he shall pay 5 shillings to the commoner, and a fine of 60 shillings. The slave is not recompensed, only the owner. Rape among slaves was met with the severest penalties. Okay, so we were dealing sorry. We're dealing with law. So basically, a person of slave status had no value placed on his or her life. So this is dealing with citizenship. William Blackstone, who was a English jurist in the 18th century, document 1, commentaries 1, 354 through 357, 58, 361 through 62. This was written in 1756. The first and most obvious division of the people is into aliens and natural-born subjects. Natural-born subjects are such as are born within the dominions of the crown of England, that is, within the allegiance, or as it is generally called, the allegiance of the king, and aliens such as are born out of it. Allegiance is the tie or ligament which binds the subject to the king. Return for that protection which the king affords the subject, the thing itself, or a substantial part of it, it is founded in reason and the nature of government. The name and the form are derived to us from our Gothic ancestors. This was the law, English law, that was used as the basis of the 14th Amendment. Allegiance, both expressed and implied, it is, however, distinguished by the law into two sorts or species, the one natural, the other local, the former being also perpetual, the latter temporary. Natural allegiance is such as is due from all men born within the king's dominions immediately upon their birth. It says, born within the king's dominions. For immediately upon their birth, they are under the king's protection at a time, too, when during their infancy they are incapable of protecting themselves. Natural allegiance is therefore a debt of gratitude which cannot be forfeited, canceled, or altered by any change of time, place, or circumstance, nor by anything but the united concurrence of the legislature. An Englishman who removes to France or to China owes the same allegiance to the King of England there as at home, and 20 years hence, as well as now, for it is a principle of universal law that the natural born subject of one prince cannot, by any act of his own, no, not by swearing allegiance to another, put off or discharge his natural allegiance to the former, for his natural allegiance was intrinsic and primitive, and antecedent to the other, and cannot be divested without the concurrent act of that prince to whom it was first due. So, go on, but now we will deal with the Dred Scott decision. Dred Scott versus Sanford, 1857, National Archives. In this ruling, the U.S. Supreme Court stated that enslaved people were not citizens of the United States and therefore could not expect any protection from the federal government or the courts. This opinion, the opinion also stated that Congress had no authority to ban slavery from a federal territory. In fact, let's go. Well, let me see, this is already opening. This skip past here. This is interesting. A free Negro of the African race whose ancestors were brought to this country and sold as slaves is not a citizen within the meaning of the Constitution of the United States. When the Constitution was adopted, they were not regarded in any of the states as members of the community which constituted the state, and were not numbered among its people or citizens. Consequently, the special rights and immunities guaranteed to citizens do not apply to them, and not being citizens within the meaning of the Constitution, they are not entitled to sue in that character in a court of the United States, and the circuit court has not jurisdiction in such a suit. The plaintiff having admitted by his demurrer to the plea in abatement that his ancestors were imported from Africa and sold as slaves, he is not a citizen of the state of Missouri according to the Constitution of the United States, was not entitled to sue in that character in the circuit court. But if the plea in abatement is not brought up by this writ of error, the objection to the citizenship of the plaintiff is still apparent on the record, as he himself, in making out his case, states that he is of African descent, was born a slave, and claims that he and his family became entitled to freedom by being taken by their owner to reside in a territory where slavery is prohibited by act of Congress, and that in addition to his claim, he himself became entitled to freedom by being taken to Rock Island in the state of Illinois, and being free when he was brought back to Missouri, he was by the laws of that state a citizen. Okay, so this, again, using this, aliens versus natural born subjects, law of England, was basically used to overturn the Dred Scott decision and to produce the 14th Amendment. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens sorry, are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. And then going back here to slavery in Anglo-Saxon England. Slavery had no wergild. So here, click on this, explaining what wergild is. Wergild, literally mangold, the amount of money each man's life was valued at. The law of Ethelbert, a 7th century king of Kent, Kent was a kingdom in England, for example, valued the life of a nobleman at 300 shillings, equivalent to 300 oxen, and a churl was valued at 100 shillings. By Alfred's time, reign 871 to 899 AD or CE, a nobleman was held at 1,200 shillings and the churls at 200. So basically, wergild was what you had to pay to a person if you injured them, or if they were killed. Um, the other person's family had to pay the family of the deceased person. A slave had no wergild. So now with reparations, people, and I would be included within the group who would supposedly be owed, are calling for monetary compensation for slaves. However, as we see before, we can see clearly that they used, again, Article 1, Section 8, Clause 4, citizenship, as the basis for overturning the Dred Scott decision. That is all. Thank you.